It is my pleasure to introduce to you today Susanna Brown. She is an attorney with Anthony & Brown in Hickory, and she is also my attorney who I met when I moved to North Carolina. So I had the same accountant in Georgia for many years, and he was a very good personal friend of mine. And I said, okay, what do I need to know now that I'm moving? Give me, what am I not thinking of? And he said, well, are you going to have an attorney to get your wills redone, get all this taken care of? And I said, well, I don't have a will. And I've got 2 kids, and he let me have it, to say the least. So this is one of those things you just don't think about when you're in your early 40s, right? So he did some research and recommended Susanna to me. And my mother-in-law and father-in-law, who are in their late 70s, decided to move with us as well. So Susanna had no idea what she was getting into with all of us when she agreed to take us on as clients. But it has been really phenomenal just to work with her and to have the peace of mind that comes along with really having things prepared, things that you don't want to necessarily think about, but there is a real sense of peace that you have once you've gone through the process. My father-in-law is I'm trying to think of another word besides stubborn, but he's stubborn, so he's not here, so I'm just going to say stubborn. But Susanna is one of his favorite people, and I've never met anyone. Now, I've been in academia for 17 years now, met a lot of really smart people, never been around anyone that knows their stuff better than Susanna does. That's saying something. She received her doctorate of jurisprudence from Mercer University School of Law. So she spent some time in Georgia too. She's a former judge in Georgia. So we were really, really lucky to have her come speak to us today. So let's give a warm welcome to Susanna Brown.
Thank you, Gavin. What? Turn on.
There we go.
All mic'd up. Hi, everybody. Hi. So glad you're here. So, let me tell you how I tend to do these. I am really informal. So, as I talk, if there's a question you have, just go, oh, I don't understand that, or will you clarify that? And I have an additional comment about that. That's great. Okay, interrupt me, feel free to. My goal is for you to leave here and actually feel like you got something out of it. I'm sure you've sat through things and been like, yeah, I don't really know and feel like I have any actionable steps to take. So I feel like I've accomplished something if you actually leave and you feel like you can take something tangible away from it and go do something, okay? So that's what I'm hoping to accomplish. And I'll let the talk kind of be guided as to what your interests are. So as you kind of give me some feedback, I'm going to kind of maneuver in that territory. So I'm going to start off where I start off with every single client that walks through my door. And I always tell them the first thing I want to do is that I want to look after you while you're breathing. Every single time, that's the first thing I'm going to tell them. Because people have a tendency to go see estate planners and people who do elder law, and they're thinking death, right? I'm going to die, it's death. No. Back up. The very first thing you need to be concerned about is looking after yourself while you are breathing. So let's talk about breathing documents. That's what I call them. All right? They're the ones while you're still here. So I'm going to start off with the financial or durable. Some are springing. I'll tell you about the difference in a second. Power of attorney. Okay? Really important document. gets glossed over so many times. People just don't recognize how important it is. So, what is that document? It's basically I call it a toolbox, all right? It's a whole bunch of provisions in a document that allow for you to name someone, which under North Carolina we call them the agent, which allow you as the principal to name an agent to do certain tasks on your behalf if you can't do them yourself. Or if it's a durable one, you simply don't want to, okay? So, you can lay that toolbox full of all the different provisions that you can allow this person to do. So many people think of financial powers of attorney and they think, oh, you mean so somebody to pay my bills, right? Whenever I'm sick or I have dementia or I've had a stroke. I'll tell you right now, the last thing I'm worried about is getting your bills paid. Somebody will make sure that they get their money. It always happens. That is not really my concern. There is so much more to that document. And please, please, please listen. And don't turn your ears off yet if you're like, oh, I have one, I did it, I'm good. Because maybe you are, maybe you aren't. Because a lot of those powers of attorney are what I call weak powers of attorney. Because remember me talking about all the different tools you can put in it? So many people will have those old, or even the new, statutory powers of attorney that are the ones you can print offline, which I'm not necessarily saying all of those are bad, but you better know what you've signed. And so many people don't. They have a false sense of security when they sign it. Okay, they think, I've named the person I trust to be my agent to do these things for me, and I'm covered, right? Well, right now, the problem with those powers of attorney oftentimes, unless you go home and you really read it, if you have one, is that if you haven't allowed your agent to do certain things such as gifting, right of survivorship changes, the ability to self-deal, which means to give to oneself, and certain specific things dealing with real estate, then if you wind up in a nursing home and, for lack of a more sophisticated word, crazy, okay? You're in a nursing home, you're crazy, you're out of your mind. Then if one of your loved ones, your spouse, your child, or whomever it is comes to me and says, Susanna, help. I want to try to protect some assets, get them qualified for care. What can we do? Well, guess what? My hands may be tied as the attorney to help them if you have not given them the ability to do some of those things I just mentioned. And I think you're probably here because you have some interest in that. Most people are. So if you have any interest in doing asset protection, if you wind up in a nursing home, your very first line of defense is that power of attorney. Very first line of defense. And it is not your typical power of attorney. Let me say that again. If you have a statutory power of attorney, the newer ones, when I say newer one, in 2018, North Carolina changed and we adopted a different kind of power of attorney code. It's now we're now part of a uniform power of attorney code. When we changed and we adopted that new law, we have a new statutory form. And on that form, you may have actually initialed the part that dealt with gifting, but you probably didn't read it close enough to notice that it limited it to whatever the current gifting amount is for taxation purposes. Meaning like, okay, yeah, my agent can gift, but only if it's okay under the current tax codes that you don't have to file a gift tax return. Well, right now that's $19,000. Well, if we're trying to gift pieces of property, probably going to be gifted more than $19,000. So even with that, even if you have the gifting, even if that you have a power of attorney, you better make sure you didn't accidentally limit it in manners you didn't mean to. Okay? That being said, let me make a cautionary note about that. When I talk to clients about powers of attorney, the financial one, I really like to have lots of tools in that toolbox, but in the hands of the wrong person, guess what? That means they can rob you blind. There's no nicer way to say it. I can put every kind of provision to prevent abuse, but it doesn't matter if you name a thief as your agent. Okay? So you need to be really careful and really thoughtful about who you're going to name as the person to carry those things out for you, who you're going to entrust as your fiduciary under that document, if you can't do that stuff yourself. And you've probably all lived long enough that you've heard some horror stories, right? That somebody's probably abused that document. Well, they exist. They absolutely do. So you must be very careful about who you name as that agent. Another thing is you really need to name some alternates. I see people if you're lucky enough to have people you trust in your life, more than one, okay? I see all the time where people will simply name their spouse, or they'll simply name one child even though they're lucky enough to have people they trust. What's the problem? You and your spouse are in that car accident. Spouse dies, we're in the same boat again, are we not? If you're now incapacitated and you didn't have an alternate on that document, think ahead. Think about the longevity of that document. If you can name more than one person on it that says a principle, if this one can't do it, then do an alternate, then do another one, then do that. It can be really helpful. Because a lot of times people really don't like to continuously revisit these documents, and I don't blame you. And I will talk about when you should revisit them in a little bit. Springing. Let's talk about springing. So springing powers of attorney can technically go into effect and spring into action upon an event. Typically, it's when a physician says that you're not competent, okay? And some jurisdictions do those. Georgia would do them more often. We have a tendency to do them more often there than in North Carolina. They're not necessarily inherently bad. They give some security to that person who's worried about it, about that sort of thing. But I will tell you one thing to be careful about with them, because I've dealt with it. In an emergency situation, that doctor's going to be on the golf course. That stinks. If you have to hurry up and get something in place now, we got to get a doctor to say you're incapacitated. See the pain? That's not fun to have to do. I've seen some that have drafted that said it's only upon the recordation and the originals held in my attorney's office. Well then, what about if it's a weekend? What about that attorney's gone? That's not really good either. Just know that there's pros and cons to both. It is not necessarily a wrong or a right, it's what's right for your situation. But those are kind of my 2 cents about them, but those are great questions. Those are all things that people should be concerned about. I will say one last thing before I go on. I have clients who will struggle and they'll say, who should I name? I don't want to hurt one of my kids' feelings. And as a joke, I tell them, name them the one you don't like. It's a job. You're not giving a kid an inheritance. You're giving them a job. If you have ever served as an agent under a power of attorney, you know it. Be selfish in this moment. You pick the kid that's going to do right by you. That's what you do. You don't pick worried about whose feelings you're going to hurt. You do it and you say, who is going to do the best job? That's what you do. You be selfish in this moment. And again, I'm telling you, you're giving them a job. You're not giving them an inheritance. And I just don't think worry about that should come into play with that particular document. Okay? So, anything, just please realize how important that document is.
That brings up a good point. Should you name 2 people as attorney, power of attorney?
Yeah.
What in your experience has that been a bad situation?
That's a good question too. So I would never name true co. And what I mean by true co-agents is meaning that they both must act together at all times. And I'll give you 2 reasons for that. is one, it becomes too arduous. It's too hard. Trying for all the decisions that would have to be made, it becomes really hard to get those two people to do everything. The other reason is that certain institutions, especially big banks, Bank of America, Truist, those sort of banks, they won't honor if it's true code because the liability's too big on them. They will give you every hard, they will make it so hard for you, or make it hard for the attorney usually, to try to honor that document. It's a real pain, okay? So be real careful about true code. What we normally do is something called jointly and severally. I'm saying like you sever something, you cut it in half. So jointly and severally could work, and what's nice about that is it lets you basically tag team two people. They are on equal legal footing. One can act or the other can act, and they can both act alone, okay? The nice thing, again, is it lets them divvy up work. All that responsibility doesn't fall on one person. The negative about that, and of course there's a negative, they dang well better get along. If you're going to name two people who do not get along, they're on equal footing, right? This one does not like what this one did. What will they do? Undo it. They have the same power. They'll just go and so if I've got two people butting heads, we're going to wind up in court. I was trying to avoid that. We're trying to not wind up in court. So don't name two people who cannot get along for your well-being. Don't do it. Again, be selfish in this moment. But now, it can work really well in the right family dynamic. And it just depends on what that looks like. I will tell you, I've also had times that whenever I've had a spouse who is aging and perhaps has some health issues and a child do jointly and severally. Sometimes that can work pretty well also because that spouse then is getting some, or they're getting some support from that child when they need it. I've seen that work well at times. Okay, but I mean, again, I wouldn't do it if that child is going to be super combative or have disagreements. That's really not the point of that document. I mean, or of an agency. You want two people who can agree. All right, anything? Yeah. That's okay.
Okay, so given that any one of us can give advice last month, what point should you pursue setting this up?
Now, so I'm of the opinion with a financial power of attorney, you really should set it up. Oh, I'm sorry. Yeah, so he just said, any of us could get hit by a bus, none of us are promised to help you tomorrow. None of us. And so when should you pursue setting it up? And my comment with that particular document is the minute that you have, one, assets you wish to protect, and two, someone that you don't want to judge making the choice for you as to any of your legal business concerns, that you would rather choose who that entity or that person be. Most people don't want entities.
I'd like to, if we have a power of attorney that is now 35 years old, is that still valid?
Sure. So the power of attorney would still be valid. Yeah, it's not validity. Just because the law changed, in no way, shape, or form did it invalidate that document. What it did do is it probably limited it more than you thought it did, because the new law retroactively applied its provisions to all powers of attorney. And a lot of those old powers of attorney had a tendency just to say, in a roundabout way, anything I could do, they can do. I mean, it's not quite that simple, but they sort of said that. The new law says you must be very specific if you're going to allow them to do gifting, right of survivorship changes, which I'll talk about in a minute in conjunction with land, self-deal, to give to themselves, beneficiary changes. So all of a sudden, it applies to even those old ones. So the problem is it wound up limiting a lot of those provisions that we as attorneys use as asset protection when someone has to go in a nursing home. It now has limited, the stuff that if someone's in la-la land in a nursing home, they thought their agent could do this kind of stuff for them. Well, they can't under those old powers of attorney. And those old powers of attorney didn't account for that because they didn't have to. The law didn't require it back then, but they do now. And for the most part, it was good. The law makes you do that now because of what I said about people robbing people blind. People would sign those documents and not even realize the power they were giving away. So they wanted now for people to be very explicit and say, yeah, this is the kind of power you're giving this person. You better realize it.
So those of us who have old ones should revisit.
Yes, revisit them, please. And again, the old ones may be perfectly sufficient for your circumstance, but they may not. You just better if your intent was to give your agent the power to protect your assets if you went to a nursing home, that sort of thing, there's a good chance it will not allow them to do that. Okay? So, that's your first line of defense. All right. Healthcare power of attorney. I'm just going to touch on it for just a second because we got too much other stuff to get through. Healthcare power of attorney, another important document, same concept except you're dealing with your body, okay? That's dealing with your person. You certainly would still want to have a document in place saying who you trust to do that for you. I will say if you don't have it, it goes to your next of kin. Now that's under statutory law. That is not the case with financial or business stuff. That's when you wind up in a guardianship in front of a judge. Don't get those two confused. I'm talking about your body, over your person. If it's over a bodily concern, the default would be next of kin. For some people, they would be fine. For other people, they'd be absolutely not. No way, circumstance could this person be over my body. Take that into consideration. Okay? Because absent you having that document, and I'll just say this and let it really set in, your decision to not make a choice is a choice, because North Carolina's already made one for you. I have people all the time who will drag their feet and be like, I'm just not going to do it. And they think that that means, oh, I still have everything. I have everything under control. I'm controlling it all. You're controlling nothing. You've given all your power to the state of North Carolina. We'll get to that in a second whenever I talk about who your stuff will go to if you don't have a will. That really blows their minds. Then they get real mad. So your decision to not do anything is a decision. You've handed your power over to the government. Period. Don't be so naive as to believe that you still retain all your power. No, you're not. Not at all. I much prefer my clients to look after themselves. I want you to have that stuff. I want you to retain your power, not someone else. Okay, so healthcare, again, same concepts. You choose people who are going to look after you, have alternates. They're oftentimes, it'll be a 2-in-1 document. So in North Carolina, you'll hear healthcare power of attorney, declaration for a natural death, living will, advance directive. All of that stuff. It sounds like all fancy blah, 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 legal mumbo jumbo. Okay, the biggest thing to remember is a healthcare power of attorney. Sometimes you hear them called healthcare proxies, but that's normally in different states. That's the person who makes the healthcare decisions for you. Okay? That's it. That's that document. The declaration for a natural death, the living will, that's the one that says whether or not you want to be kept alive by machines when the doctor says there's no hope. That's the one where you get to make that choice. That's that document. The living will has nothing to do with disposing of your stuff at death. It's about whether or not you want to be kept alive by machines. Okay? That's what that one is. An advance directive is a combination of both of those. That's all it is. Please make, yeah.
Where does the 5 wishes document fit in with those?
That's a good question too. So those 5 wishes document is almost like an extra little blanket of extra direction on top of that document. is what that does. It lets you get more specific, is what it does, and it's a lovely document. Because the power of attorney and the natural debt are pretty, they don't get real specific about exactly what you want to receive in those end-of-life situations. That one does. And the MOST form is another one you fill out with a physician. Have you heard of MOST? Can't get the acronym exactly right now, but that's another one. They do not override each other, they fit in conjunction with each other. They complement each other, in other words, okay? So they're all good to have. It just lets you be more granular in what you want. Yeah,
Which one did you say was a combination of both?
advanced directive. Yeah, you'll hear them called that. Somebody have another one. Again, important if you do that document yourself, again, and you certainly can. The only thing I will say this, the statutory form for North Carolina that they have available online is really, really rather confusing. It really is. I mean, you better read it real carefully. I can't tell you how many times I have seen that document filled out and I tell people what they did and they go, what? That's not what I meant to do. It's a weird kind of, it's not laid out very well. So if you do that document, you make sure you understand what you're signing, okay, and what your intent is. The other thing is, if you do that, please make sure your witnesses are not family members or people who are going to benefit from your demise. They can't be witnesses on that document. I've seen that happen before, and you got to have a separate notary from the witness. So just be careful about that. HIPAA is just a complimentary document with that. HIPAA is the one that says it's just a release of information. You can always have an extra document in regards to that. The other thing I'll mention this real quickly. North Carolina Secretary of State will allow you to take your healthcare power of attorney and you can actually send them a copy for $10. You have to pay $20 if you have two separate documents, like a living will and a healthcare power of attorney. If they're combined in one, you just have to pay only pay the cost of one $10. And if you do that, they'll send you back a little card, okay? And the card, essentially, I tell clients to keep it behind your driver's license. But anytime people ask you, have you got a healthcare power of attorney? Do you have a living will? All you have to do is hand them that card. And as long as they have internet access, they can print it off, which is kind of nice. And so in North Carolina, we have a public registry that's really cheap. If anybody wants to take advantage of that, just know that exists. And it's open to anyone in North Carolina, should you care to do it. Just go to the North Carolina Secretary of State and look up the healthcare registry.
That's what I want to know, Secretary.
Yeah, Secretary of State. And again, super cheap compared to a lot of other places. Incredibly cheap. One more quick thing about that one is I will say, don't forget the fact that there is a difference between a living will and a do not resuscitate. I have clients who come into my office and they'll say, Susanna, I want to do not resuscitate. And I look at them and I'm like, absolutely not. If you fall over and you're not breathing in my office, I want them to resuscitate you. Are you crazy? Of course. I mean, there's a difference there. A do not resuscitate, you think emergency. You think your heart stopped. You quit breathing. Something happened that if somebody doesn't jump on you right then and there, you're going to die. That's not the same as machines keeping you alive. Okay? Do not resuscitates are typically filled out with doctors, hospice. They're filled out in nursing homes. They're filled out in facilities or with people who are under an obligation to get your heart going. That sort of stuff. So those are just different. They're just different. All right. Any questions before I move on? All right. Good. Yeah.
Maybe this applies to others. You did all this in another state and then you moved here to retire.
Okay. Sure. So I'll mention on two different of the documents. Financial power of attorney, you absolutely need to revisit, okay? And I will tell, it's not, and let me preface that, it's not that it may not be honored, even more interesting. So each state has their own little nuances. And most states, I say that with a, most, not every state's a little weird. But if it was executed correctly in that state, they'll honor it in this one, okay? And most of them, or they'll say if it meets the same requirements of that state, they'll honor it. Let me tell you why I say you still need to do it. Because each state, because they are so nuanced, there may be provisions lacking in that power of attorney you really need in the new state's power of attorney. That's why. That's why I say you need to revisit it. The healthcare power of attorney, still important, but maybe not quite as important. And why is because most states are pretty big about making sure that those documents are going to be honored in most other states. The only reason why you may want to is because of the fact that if you get into a facility and they see that it's in a different state, it could cause a little bit of a hiccup, because technically the law says, well, they have to go and see that it was validly executed in that state. Well, clickety clack, how many witnesses did this state have to have? Was it done correctly in this state? That in an emergency, who wants to worry about that? You see? So it's not so much that it legally is invalid. It's just that it will probably cause you problems. That's where it gets to be a little tricky. And I don't ever want my clients to have problems. I would much rather you be okay. So that's the answer. It's not that it's automatically invalidated. That's not correct. It's just that it may be a little bit more a pain. All right, now, let's talk a little bit about the death part. Got you looked after while you're breathing. Now we're going to talk about death stuff. And I'm going to try really hard to intertwine some estate planning with asset protection, because you can't have one without the other. And I'm going to let you guys kind of lead me as to where you're most interested in talking about. Because I'm going to go whichever one you want me to. Estate planning pieces of it. You'll hear people say, trusts are better, wills are better, you don't need one, all this kind of stuff. And I have clients who will come and sit in front of me and they, Susanna, so which one's better? And my comment is going to be, I don't know yet. It depends on your situation. I will flat out tell you right now that not every single person needs a trust. And I'll explain why in a second. That's just not true. I'm sorry, it's just not. Especially not in North Carolina. We have very, very, in general, favorable costs for probate compared to other places, okay? So just know, not everybody needs a trust. I'm just not going to say that. Some people do. Some people, it makes great sense for them to have a trust. Trusts don't fix everything. I don't know where that got in people's heads, that trusts are just fix it all. They somehow think that trusts just fix all of it. No, they don't. They can fix a lot of things. But you better know what it is you're trying to fix and if it makes sense to fix it with that. There might be other means and mechanisms to do that. There are also a gazillion different kinds of trusts. And if you ever, I am not opposed to being a Google warrior. That's fine. But especially with legal stuff, it can be pretty confusing. And all of a sudden you find out that there are revocable trusts, irrevocable trusts, one set up for asset protection, intentionally defective grantor trust, grats, slats, that, idiots, oh my gosh. And it'll make your brain go, and it should. It's confusing. It's really confusing. And I guess just know that you must know that which flavor of trust you may or may not need. Okay? And that stuff's hard. Heck, it's hard for me still. I still go back and look at it and go, wait a minute. Which one are we talking about? How do we do that? Call up somebody and make sure I'm right? I mean, that's just, we still do that. So, oh, and the last one, dying without one. There are a few cases, very, very few, but a few, especially to my clients who have very little, it might be okay. I'm sure I'd probably get, that may be where I say cut it off. Because there'd probably be some people who are like, what? But it's true. Meaning that in some cases, intestate succession may be all right for that particular client. And it may be all right because the likelihood of anything falling through probate is almost zero, or what is going to fall through is exactly the way they want it to, and they're 95 and not doing too well anyway, and it's going to be all right for them. I guess I say that just because understand there is no wrong and there's no right, there's what's right for you, okay? Period. And you must just look at your individual circumstance. So let's talk for a minute about what people have a tendency to miss and not understand. I hear all the time, well, you want to avoid probate. Probate's so awful. Well, let's talk about how to avoid probate. It's going to make sense in a second when I talk about Medicaid, in just a little bit. How do we avoid probate? Well, how many of you don't have to raise your hands, you can just think of it internally, have joint accounts, right, with a spouse? Yeah, that sort of stuff. Well, guess what happens? In my very crass way of saying it, I say that means last to die wins, right? You got two people. And I had one client who told me, she was like, Susanna, no, I have won nothing. You know, I mean that. So no, I don't mean to be callous when I say that. Just, it sticks in people's minds if I say that. So, last to die wins. You have two people. This owner dies. What happens to all the assets? They now automatically are still vested in that one owner. Does the bank say, nope, you were cutting off access? No, because you still have an owner alive. Is there any kind of forms that have to be filed to show that? No. You don't even technically have to show them a death certificate. For that matter, you probably should, but you don't have to. There's no probate with a joint account. Ownership account. Not co, but an ownership account. Okay? So there's one. Beneficiary designations, payable on death, transfer on death, all those different things. Those are contracts you make with the custodians of those funds. So you have a retirement account, right? You put a beneficiary on it. That is a contract you have made with Fidelity, Vanguard, Schwab, Ameriprise, I don't care who's it with, whoever you have it with, that upon your death, all those assets immediately vest in that new person that you've named as owner. Do you have to go through probate for that? Nope. So we've avoided probate again. Yeah.
Back to joint accounts, does that apply to deeds and titles as well?
I'll get there in just a second. That's a good question. Yep. So, doesn't avoid probate there, or that you're avoiding probate with those designations. Okay? So there's another one. So all those assets that we're worried about having to go through the courthouse and having to deal with all the probate issues with, yeah.
You do have a 401k, but you don't have a beneficiary. What happens to it?
9 times out of 10, and it depends, I know it depends, but it normally, most of the custodians of those funds say it falls to your estate, typically. Now, there's a caveat to that. Some of them will say, by virtue of their agreement when you hold the funds with them, that if you have a spouse, it will go to that spouse. Some of them will actually allow, if you accidentally don't have a beneficiary and the spouse is the only one who actually is named, I will tell you this, it's really not good for an estate to be named of qualified funds or retirement accounts, meaning tax deferred money that you have to pay taxes on. You typically don't want it to ever fall into the estate because it will get a hard tax hit. It has to be pulled out within 5 years, it's not good, all this stuff. If you accidentally ever find that a spouse was the one that was supposed to be named and the spouse, according to the will, gets everything anyway, we have found that lots of times those custodians with some special, we can write letters, and they'll let it go to that spouse anyway without it having to have that hard tax hit on the estate. So I say that just because you said what happens if you don't. Just know that that may be an option before you happen to get a really bad tax hit, because we've been successful with that before, okay? But in general, it normally would fall to your estate. And especially with deferred tax things, we typically don't want that to happen. Just because there would be negative tax implications for that under the Secure Act, which is what they're all falling under right now, okay? So, payable on death, transfer on death, all of those sorts of things. Deeds. Let's talk about land for a second. I hear them called lots of different things, but life estate deeds. I'm going to talk about those for just a second. They were very popular, still are somewhat. Wherever mom says, hey, as long as I'm alive, I get the rights to my house, but I'm going to deed the remainder interest to you. Remainder interest just means when I'm dead, all of it goes to you, okay? And you can do that with land, and they're called life estate deeds. It means possession stays with the life estate holder, and then at death, it's going to go to the remainder one, which is the person that they name is to receive it upon death. And I'm going to talk about those deeds a little bit more with Medicaid, so I'm not going to get too in the weeds yet. What happens with those particular kind of deeds is that the deed controls what happens at death, not the will, not intestate succession law, the deed. So, no probate. Immediately upon death, it all vests in that remainder person that they've named. Okay, so that avoids probate. Joint with right of survivorship deeds. You have to be explicit and say joint with right of survivorship. Again, last to die wins. You have one owner who's still alive. It all vests in that surviving owner. Okay? No probate is involved in that. So that's another one. Yeah.
Okay. If you have a deed, you are married, but it hasn't changed the deed, then it wasn't happened then, and you pass away.
Can you say that again?
Okay. You have a deed of 50, 60 years.
Mm-hmm.
You were married.
You were married to the person.
Yes.
That's on the deed.
On the deed.
Got it.
And you have never changed anything on the deed.
And they've died?
No, not yet.
Okay.
But the person, they died. Well, what happened? You died. And the person's name is still on the deed.
So under North Carolina law, if you bought a piece of property while you were married, that's called entirety's property. Entirety's property. And under North Carolina law, the minute that the first spouse dies, all interest automatically vests in the surviving spouse. There is no need to change a deed. There is no need to do anything. There's no probate. There's no nothing. You don't have to change the deed at that spouse's death.
But what if you're divorced?
Okay, that's a good question. So if it was, and you have a divorce, that's getting real in the weeds, but that's kind of a good question, I'll tell you. So in divorce, then and you're no longer, you're both still on the deed though, right? It changes it from entireties to co. That's what happens under North Carolina law. So no longer is it now the joint right of survivorship. You each own a 50% undivided interest in the whole. So that means that make it a wife, when the spouse dies, her estate owns 50% interest in that property. It doesn't go to the divorced spouse. It goes to that ex's estate is where it goes. If it was never changed.
That deed can be transferred, but not the other person's. They could be.
No, unless you've got some kind of valid court decree from a judge that says that it was supposed to have been.
But see, what it did, you split your property before the divorce, but I put on the perfect
Equitable distribution. Again, if you have a court-ordered degree saying that that such and such was supposed to happen and it never did, you might have something to stand on. You might can get it done, but I will tell you, I'd sure take it something done before they die. That would make it a lot easier. A lot easier. Yeah. Yeah.
Okay, about trusts, and some of them trapped in, some of that is part of the trust that I have. The circumstances have changed. Easy diligence is good person.
It depends. So again, some trusts, and it depends on what's changed. But you can sometimes just do a simple amendment if it's not too drastic, and that's fairly simple. But regardless, a good, thorough review of everything should happen no matter what, because working parts of that trust may be affected that you don't realize. So you should always look at all of it. But
So how can you, like, okay, then, blah.
yep.
So how much do you think we need to revisit it?
So this is my personal opinion, and I say wonderful, terrible every 5 years. Every time something wonderful happens, you need to look at your stuff and see if something has changed. Terrible's happened. Somebody's died, bankruptcy, awful. Look at it and see something's changed. Every 5 years, pull it out and say, look at it and say, if something stands out to you and is horrifying to you, you probably need to call somebody. That's my thought. Wonderful, terrible, every 5 years. It does not necessarily mean you need an attorney. It means you need to be diligent about it. Okay? Just look at it. Look at it and see if something needs to change. Look at it and see if something bothers you. That's my opinion about that stuff. So, all different ways to pass property and avoid probate.
But
Remember that. There are all sorts of different buckets. Now, let's talk for a minute about that. Because that will also screw you up, and I gotta hurry up, because I'm talking about Medicaid. So, when you do that, if you go and you name beneficiaries, and if your will gives everything to your 3 kids, and then on your life insurance you name your oldest kid because they're the most responsible and they'll do the right thing, what have you done to your other 2 children on your life insurance policy? You have disinherited them. It's amazing to me how many people don't get that. I'm like, did you mean to disinherit your children? And they look at me shocked, horrified. How dare I suggest such a thing? Well, you did. Let me spell it out for you. You did disinherit them, whether you meant to or not. And if you don't want to, let's fix it. That's all. And again, it doesn't mean you meant to. It just means that there's more to this stuff than you think about. Okay? That's what I'm trying to get at. All right, I'm gonna hurry up and do Medicaid before I get done. Medicaid. How many people here think they'll never qualify for Medicaid? I get that all the time. Never. I'll never. I have too much. I have too much money to ever qualify for Medicaid. Well, you may. Although I'll tell you, I've gotten people with millions and millions of dollars qualify for Medicaid. And people go, what? Yeah. Millions at least in assets. So I'll give you an example. There are huge differences between Medicaid that is long-term care institutionalized Medicaid and the Medicaid you think about. Because the Medicaid you typically think about is the SSI, poverty, don't have a job, disabled, right? That's what you're thinking. Well, it's a different animal if you're talking about Medicaid in a nursing home. That is completely different rules. Completely. How many of you think Medicare is going to pay something in a long-term care facility? That's not rehab. If you do, put your head down, you're wrong. It's not going to pay a dime. It's scary. How much does it cost in a long-term care facility? Anybody know in a skilled nursing facility? Yes. Huh?
11,000.
Or more. 11,000 or more a month. How about an assisted living? I'm usually at least 7. Yeah. I mean, it is astronomical how much it costs. So all of a sudden, your little nest egg is not a fee. Make it even worse, you got a spouse at home. Spouse is still living at home. Think of how fast you're draining their assets. You need to be educated and understand, okay? I'll tell you another thing with Medicare. It says it will pay for rehab, and it does, but I will promise you they'll try to kick you out real fast. Don't you ever rely on that 100 days. Don't you ever rely on that 100 days, okay? Ever. Don't sit back and bank on it. That is so naive if you do. If you ever have a problem that you feel like you are being mistreated in a long-term care facility, your ombudsman is one of your best friends. If you've never actually looked up to see who the ombudsman is in your area, you should. They're wonderful. They're really good. I've actually called them myself for some clients. Yeah.
Is this, and who do they work with in the facility?
The state,
Same?
work for the state. The ombudsmans are, and they're advocates. They're advocates to help make sure that patients are looked after.
Are they part of DFS?
No. So it's on separate little entity kind of thing. And they do a really good job. I've been pretty impressed with them. I will say another one. I want you to write this down. It's called JIMO. It's JIMMO. It's called the JIMO case if you ever do want to go and Google something. In rehab, they have a tendency to tell you that you don't qualify anymore because they have plateaued. That is the wrong standard. That is the old standard. The actual standard is one that it's supposed to be that if they were to go back home, they would decompensate. That is the new standard. That's a very different than plateaued. That if they were to be released and go back home, they were to decompensate. That is what the JIMO case is all about. There is an entire federal toolkit about how to advocate for yourself if they try to release you based upon that wrong standard. It's worth at least Googling it. It's called JIMO. Okay? Or a loved one winds up there. Yeah.
I don't really understand what you're saying.
So the way that they would say, if you're in rehab, we worked with them, we got their arm. Their arm used to go to here, but it's just going to go to here now. They plateaued. We can't get any farther. They're going to have to be released. That's not the standard. The standard is if they were to release, if this arm would keep doing this, because they're decompensating, because they didn't get further in rehab, that's the standard. That's the difference. Is because they would continue to decompensate for lack of continued rehab. That is a very different standard than they have plateaued. It's more generous. It's more generous to the person in the rehab. Okay?
Good. See?
From Medicaid, I'm going to tell you this piece of it, and I'll give you my little thing so you don't stay here all the time. How many of you know about the 5-year look back? You hear that all the time, right? So I'll give you my real quick and dirty tips about the 5-year look back. What does it mean? And this is for skilled nursing care. If you ever go and knock on the government's door and say, help pay for my care, the government will say, fine, but you better not have given anything away for less than fair market value in the past 5 years. And if you have, they're going to penalize you. For every $10,317 you gave away, they will penalize you 1 month of care. That's what that means. If you knock on their door and say, help pay for my care, they're going to say, we're going to look through all your records for the past 5 years. And if you've given something away for less than fair market value, we'll penalize you. And once it hits, and they do it per diem day too, but just for once it hits the $10,317, you're not going to qualify for 1 month of care. Okay? It's a penalization thing. They're saying you can't give your stuff away and qualify for Medicaid. Notice I said fair market value. Fair market value. Therefore, can you go and sell your house to your kid for $1? You can, but you better not ask the government for funds to pay for your care. That's not fair market value. Can you go and if you put it in a joint account with your kid, does that mean they'll only count half of it? No. And don't be so naive as to believe that. It will not fix it. They will go and see and make sure exactly where that money came from, and if it's all yours, it's all against you. Don't do this. Do not think that paying cash will fix it. Do not think that, oh, well, they cannot then trace it. Guess what? Guess who the burden is on? You're the one asking for money. So DSS is going to turn and go, okay, we see all these cash withdrawals. Prove what you paid with that cash. Do invoices, do receipts, do everything. Who has that? But the problem's yours. It's not theirs. That's a nightmare, by the way. Yeah.
About lending to an education fund. About that particularly for grades.
That's a gift. And I will tell you, the only way you'll get around that, the only way you will get around that for Medicaid purposes is if you can show an established pattern of giving. That's it. And you will have to go back many, many moons and show that you have done that for year after year after year after year after year for them to say that that was not a gift. But just because they don't care. Their argument's gonna be it should have been used for your care. That's hard. It's harsh. But if you can show an established pattern of giving, you're okay. For example, if you gave a kid $100 every year for their birthday, well, they're not going to count that gift because it's an established pattern of giving. Okay? That's sort of how that works. Again, for Medicaid purposes, I'm going to circle back for just a second because I didn't explain it. For people saying, you know, I'll never qualify. The idea behind Medicaid and institutionalized care is, yes, the $2,000 rule that you can't have more than $2,000. It's a little different if you have a spouse. I don't have time to go into it, but just know in general, the $2,000 rule. As long as your income is not enough to pay the monthly rate at that facility, you can qualify for Medicaid. Well, also gets you down to that $2,000. Period. If you're able to do something with your resources that Medicaid does not consider sanctionable, then you absolutely can get qualified for Medicaid. And so when I say something that's not sanctionable, what do I mean? Meaning, in order to qualify, remember I said you can't give something away for less than fair market value, right? Well, for real estate purposes, I'm sure some of you probably heard of Ladybird deeds, 991% deeds, life estate deeds. Real quickly, just a very elementary way of how some of these work. A 99.1% deed. And another reason why powers of attorney are so important, I'll lay it on top of this. I have a child come to me and there's only one parent alive. The parent so desperately wanted to make sure that this kid got their house because of some reason or another. All right, so they come and they're like, is there any way that we can help preserve this house? I got it, Mama's got to go on Medicaid, right? She's got to get, she's going into a facility. Well, 991% deeds work in the way that 1% is paid by the child, okay? Fair market value, which is tax value in the eyes of DSS. So you actually pay for it. I mean, the child is going to pay a 1% fair market value. The other 99% is still going to be held by mom. It will have a joint authorized survivorship clause that says upon death, if the world works the way we think it typically does and mom dies first, all that 99% will vest in the 1% owner upon death. Now, it's not quite that simple in some counties for different reasons, depending on whether it's the resident or not. Sometimes we have to layer another deed over it. And it's a little complicated, but just know it can work. And it can also work when we don't have 5 years. Even if we don't have 5 years, if we didn't get past a 5-year look back, okay, it can work. But let's make mama have a stroke and she can't do that planning herself. She can't gift, she can't do a right of survivorship deed, she can't sign anything. And I look at that power of attorney that she gave her child, and it has none of those provisions we talked about earlier. I can't do nothing to help. Does it make more sense how important that document is? It is an incredibly important document, okay? There's absolutely stuff you can still do, given the right power, as long as they don't change the law on us anytime, even if you don't have 5 years, especially in regards to real estate. There's also some stuff you can do in regards to assets. There's Medicaid compliant annuities that can happen. All of that stuff involves some pretty technical kind of things. But the important thing is that you know it can be done. You need to have the education to know that there's hope. So many people have a tendency to think, oh, I haven't gotten past the 5 years, there's nothing that can be done. That's not true. It may be true if we truly have no powers and someone has dementia and all this other stuff. But even with that, there are effective spin down methods, meaning that we have to get below that 2,000. There are things that we can spend that money on that can help enrich that person's life who's going to be institutionalized, or even possibly, move assets over or get reimbursements for expenses a child may have paid for that person. There's all sorts of things that can be done. And I will tell you, it's oftentimes worth just having an office conference with an attorney. Just going to see an elder law attorney that's what they do. Okay? What's it hurt? Other than an office conference fee. Just to ask.
Yeah.
Because many times there's more stuff available than you would think there is. And that's part of what so many people miss. It's kind of sad that they just don't think there's options, and there are options. Okay? Especially with some of that thing. There's also irrevocable Medicaid Asset Protection Trust. Just knows that's proactive planning. You must have 5 years in order to do those, or 5 years in a lot of assets otherwise too, in order to get past the 5 years. Those things can work really, really well, but they've got to make sense for you. If you ever go and look them up and say trust protected for Medicaid, they can be great, but you better know what you're doing, okay? And I will say that they're not right for everybody. We're going to ask a question.
Yeah, ask what question? Right, but on the law attorney.
I am. Yeah.
So we talked about penalties with environment transfer, it's said about 5 years. That the town give us these manifest, is it a fine any?
Yeah, exactly. They just say you're not qualified for Medicaid. And so what happens is that they have to cure the penalty. So for example, if there was an improper transfer of real estate, they have to transfer that real estate back. And then they'll cure it and let them qualify.
So it's a yes.
Yeah. If,
That proves happening.
yes. And that's how it almost always is fixed. Because otherwise, what are you going to do? Exactly.
You could,
Yeah, the worst thing that you see sometimes is like I've had this happen before, a grandparent gave,
do work.
more like somebody stole it, but anyway, a grandchild money, and they just went and ran through it. They're like a drug addict, ran through it. Well, we can't get it back. I mean, we can't not get it back, and this person desperately needs care. So what happens? They're going to bring criminal charges for elder abuse against that grandson, as they should. But it has true life consequences. I mean,
Good.
those gifts, they will go after them. I mean, just so you know. I mean, they're getting more and more aggressive too with that stuff. I will also say, this is new in North Carolina, a few people know this. Unless the estate has at least $50,000 worth of assets, Medicaid's not going to file a claim. that it used to be the rule that it is now. So for example, if there was a vehicle, because you can have one vehicle qualify for Medicaid, and that was a nice vehicle. The vehicle was worth $45,000. It used to be that Medicaid would come and try to claim that. They don't anymore, because it's not at least $50,000. So there's just all sorts of nuances to it. If you have a child who lives with you and has been living with you, taking care of you for at least, a few years, there's a possibility of a caretaker child exception for the house. If you own a house with a sibling and you live in the same house and they're also on the deed, there's also a way we can protect it then. There's just interesting exceptions all around. That's the reason I'm trying to point out to you, there are options. There are things that you be smart enough to know what you don't know. All right, guys, any other questions? If not, I'll stay up here, okay? And then we'll take questions if you need me.
And of course, you keep asking, but it's
Yeah,
$2,000, what I said, sir.
not countable.
Yeah.
So you can own a house up to a certain, unless it's a really, really expensive house, but you can own your house. But notice I said you can own your house for qualification. That doesn't mean they won't take it at death if it's still in your estate, okay? They'll still come take it, but you can qualify and still own your home. But we got a problem with death. You can own a car. You can own certain burial insurance policies to get you buried. Not worth a lot of money though. Just that they've changed that a little bit too. You can own certain interests in business, but that's very limited. But those are kind of your biggest exceptions that you're looking at. Now, if it's a spouse, there's a certain amount of assets that we can protect for that spouse that's still at home. And there's all sorts of ways that we can help give them more. But just know that that's a little bit more complex planning to do that. But we always try to get that spouse as much as we possibly can. But long story short, they try to take everything. It's pretty much they make you spend down to poverty. That's what it amounts to. Medicaid's tough. And they change the rules all the time. They can even hurt. I just want you to know that there is a hope. So many people think that there's nothing you can do, and that's just not true. It's just not. There are things you can do. Okay? All right, guys. Like I said, I'll stay up here if you need me. And I will answer. Yeah, you're welcome.
And talk about
Oh,